There is a development in another legal case involving former President Trump in that range. NBC News can now confirm that a U.S. district judge ruled the Department of Justice did present sufficient evidence to establish Trump committed a crime through his attorneys relating to the classified documents found at Mar-a-Lago. Judge Beryl Howell issued her decision in a sealed filing last Friday. It's important to note Judge Howell was not ruling on whether Trump was guilty of a crime, but was making a decision on whether his attorney could be compelled to testify. The judge ruled in favor of applying the so-called crime fraud exception, meaning Trump attorney Evan Corcoran cannot claim attorney-client privilege to avoid testifying. This is pretty big.
Yeah, it is.
The judge ruled in favor of ordering Corcoran to testify before the grand jury convened by special counsel Jack Smith, who's currently investigating the former president's handling of the classified documents after leaving office. At the same time, the Washington Post reports a federal appeals court ruled yesterday to uphold Judge Howell's ruling, ordering Corcoran to turn over notes, transcripts, and other evidence to prosecutors and to return to the grand jury to answer prosecutors' questions more fully. CNN and CBS News both report Corcoran is scheduled to testify before the grand jury tomorrow.
Andrew Weissmann.
Wow.
You know, Meek will tell you I'm just a simple country lawyer.
Oh,
I'm not one of these big city lawyers like you.
No, but this seems more pressing.
But even a simple country lawyer like me can look at this and know this is really bad news, not only for Donald Trump's attorney, but for the client himself. Can you just talk about, seriously, can you just talk about how unusual it is for a judge to allow prosecutors to pierce attorney-client privilege?
And what are they looking for?
And exactly what that means.
Yeah.
Sure. Well, I think you're both right that this could be a critical and huge development in the Mar-a-Lago case, because this could be opening the door to Mr. Corcoran giving direct evidence with respect to the former president obstructing that investigation. Now, why is that? It's because Mr. Corcoran drafted the certification in June that was given to the Department of Justice, and that certification said that all documents responsive to a subpoena had been produced. And everyone knows that, in fact, was not true, because a search was done and there were documents responsive to the subpoena all over Mar-a-Lago, including in the former president's office.
Let me ask you, Andrew, is this to stop the attorneys from pointing at Trump and Trump pointing at the attorney? So the attorney said, well, we only did it because Trump lied to us and told us that he'd given us all the documents, and to stop Trump from saying, well, the attorneys lied. I mean, this really stops that, doesn't it? Calls it out, and we find out exactly who was lying.
Absolutely. And the reporting is that Mr. Corcoran's going to say, it wasn't me. I wrote this, but I was told what to put in there by my client, meaning Donald Trump. So you're absolutely right. This is a way of getting that direct evidence. Is how did that certification come about? And yes, it is very unusual for the prosecutors to seek this kind of order from the court. It is not something that's never happened. It happened during the special counsel Mueller investigation with the exact same judge, but it is unusual. And in order to make this ruling, the judge has to find that it is likely that Donald Trump committed a crime. It's not necessary that the lawyer did, but at least the client did. And the standard is likely. That's exactly what she wrote in the Manafort case that I handled. So this is a huge deal. But in terms of the case, this really could be the key evidence of obstruction. And it also differentiates this case from what we know about the Pence case and the Biden case, because there's absolutely no circumstance where we're thinking there's obstruction and false statements made. So this could be a critical difference as to why the department treats Donald Trump differently than those other two cases.
And it's key for everybody listening. What Andrew just said is, court's not going to do this unless it is, quote, likely that Donald Trump or his attorney or both committed a crime. And Ken, I want to underline one other point that Andrew just told us. people are looking, Republicans saying, oh, this is the same thing that Pence did. This is the same thing that Biden did. This is the part of the Trump case that we've been saying for a long time, and that other people have been saying for a long time, is the key. It's not the documents themselves. It's the obstruction in returning those documents and swearing that you have returned those documents when, in fact, you haven't. Talk about how this goes to the very heart of that issue that many people say is what differentiates this case from the Mike Pence case or the Joe Biden case.
100%, Joe. That is the significance of this development. And look, even if you leave this aside, the Trump situation with more than 100 classified documents found in an FBI search, some of them TSSCI, is much different from the Biden and Pence situations because some of those documents were found in his office. This wasn't an issue where they were inadvertently packed and stored and he didn't know about them, at least according to that circumstantial evidence. But now you take it a step further. When I talk to current and former DOJ officials about whether this case will be charged, there's always a reluctance. The idea that you're going to charge a former president with simple mishandling of classified documents that he once had access to and that were sent to his house, that's a tough case. It's not impossible, but that's a tough one for the special counsel to bring in for Attorney General Merrick Garland to sign off on. But when you have clear evidence of obstruction of justice, of lying, to fail to comply with a grand jury subpoena, that's an easy decision for them to make. In fact, they can't turn away from that. And now we have a federal judge saying there's substantial evidence to believe that's exactly what happened. And it's always been a question, who lied to the government? Was it the lawyers or was it Trump? Or I guess the third possibility is nobody knew those documents were there. Well, the evidence argues against nobody knew they were there. And now it's looking increasingly like the evidence suggests that it was Donald Trump who caused that false affidavit to be submitted to the Justice Department.
And those attorneys drafted and signed a document that said, all clear, there's nothing left here. Then, of course, the FBI went in later and found more than 100 more classified documents. So, Andrew Weissmann, there's been a lot of talk, including some people who've come on our show and said, boy, they shouldn't have gone first with the Manhattan case. They shouldn't have gone first with the Stormy case. It feels like old news. George is more important. The documents, January 6th, these are more important. But obviously, these four cases are being conducted in these investigations by different people with different sets of facts without concern to the others. So what's your sense of the way these are rolling out and how they may impact each other as they do come down?
Well, I think, Willie, your point that these are different prosecutors is key. Yes, if this was one prosecutor, you might ask the question, why this one first? I don't think that the Manhattan case is negligible, but it certainly is not as serious as the events that happened in January 6th, the potential overthrow of Democratic presidential election, or the retention of highly classified documents and obstruction of a federal investigation. But these are three separate prosecutors. This is not like a TV show with one producer where you figure out what should we lead with and what should go second and what should go third. And I basically say to people a little bit like what Jen Psaki said, which is, have patience here and let the process play out. We could find ourselves in a matter of weeks or months where all of this is something that is indicted. And the fact that this case in Manhattan goes first becomes sort of a footnote to history. Because we really could have a very different set of facts very soon.